Chief Arbitrator, honorable members of the tribunal, it is important to begin our submission with a quick remark on the jurisdiction of this case. Chief Arbitrator, while we note that the instructions of the competition has already considered jurisdiction and admissibility, it is important to highlight, according to Article 22D of the FIFA statute, that the FIFA Dispute Resolution Chamber is the one which has the appropriate jurisdiction to entertain this matter. That's also been provided for in Article 50 sub 2 of the 2024 FIFA statute, that it is upon the exhaustion of the internal mechanism of FIFA that a dispute can be brought before the court for arbitration for sports. However, as already adduced, we recognize the fact that this has already been waived in the competition manual. Thus, we will now proceed to our merits. Esteemed arbitrator, on our first merit, we submit that the claimants are not entitled to training compensation because they have failed to register Emperor, the player. The thrust of our submission is that forced registration as a professional is the element triggering the payment of training compensation. Esteemed arbitrator, one key submission is made to advance this argument. That is, the earning or signing of a forced professional contract is merely a preliminary step to professional registration. It's merely a preliminary step to professional registration. Esteemed arbitrator, the clear words of Article 20 of the RSTB provides that training compensation shall be due to a training club upon the player's first registration as a professional. The same provision is captured in Article 2.1 of Annex 4 to the RSTP. Esteemed arbitrator, in order to prevent any ambiguity regarding the import of signing a first professional contract, Article 8 of the RSTB provides that the application for the signing of a professional shall be accompanied by a player's contract. In fact, the second part of that same article, it provides that the relevant member association, which is the Nigerian Football Federation in this case, has the discretion to consider additional contractual materials before deciding on the player's first registration. Esteemed arbitrators, the import of this is clear, that the mere earning or signing of a first professional contract is not conclusive proof of the professional status of a player. In application of this to the foregoing case at hand, paragraph 3, line 1 of the Moot problem clearly states that Emperor only earned his professional contract after a brilliant 6-month stint as an amateur at the Respondent club Enugu Rangers. It would also interest this panel to note that throughout the whole 6 paragraphs of the Moot problem, the word register was used only once, and it was used in relation to Emperor registration as an amateur with the Respondent club. We submit that this is obvious a deliberate attempt to show that there was no attempt, there was no proper documentation, and there is no form of evidence to suggest or plausible argument or inference that shows that Emperor was registered with the Respondent clubs. Furthermore, esteemed arbitrators, this position has been buttressed in a plethora of cases. In Danang FC versus FC Banik versus FIFA, the CAS panel established that forced registration as a professional is the element trigger for the payment of training compensation. This position and rationale has also been established in the case of FC Bologna versus Barcelona, and also established in the case of Bayer Leverkusen versus FC St. Gallen and FK Sarajevo. All citations duly provided in the Respondent Memorial. Honorable members of the tribunal, in spite of this established jurisprudence, there appears to be a misguided notion that the first signing of a professional contract is the element triggering the payment of training compensation. This flows from the inconsistency in the previous editions of the RSTP. In Calcio Catania versus Montevideo Wanderers, the CAS panel examined the element triggering the payment of training compensation, considering Article 20 of the RSTP, which provided that first signing of a professional contract is the trigger element for the payment of training compensation. But in this same case, the panel considered Article 2, paragraph 1, and Article 3, paragraph 1 of Annex 4 to the same RSTP, and noted that the first registration as a professional is the element triggering the payment of training compensation. Sadly, we recognize that the panel ruled in this case that it is the signing of a first professional contract that is the element triggering the payment of training compensation. Esteemed arbitrator, it will interest you to note, however, that this statutory inconsistency has now been rectified in the RSTP. Article 20 of the RSTP 2022 edition clearly provides that training compensation is payable to a club upon the player's first registration as a professional. And the same provision is captured in Article 2.1, Annex 4 of the RSTP. Honorable members of the tribunal, the paragraph 3, line 3 of the Moot fact is clear on the fact that the word end was used. The word end does not suggest that he was registered. It only means that a false professional contract was given to him. Esteemed arbitrator, we submit that even if this panel believes that false registration as a professional is not the element triggering the payment of training compensation, we note that this case is instituted on the basis of the fact that the claimant contained in paragraph 4, lines 2 and 3 of the Moot fact that they have waited for 6 months to see a change reflecting empirical status as a professional. However, we would like to draw the attention of this honorable tribunal to the provisions of Article 3.2 Annex 4 of the RSTP, which provides that the deadline for the payment of training compensation is 30 days following the false registration of the player as a professional. Esteemed tribunal, it is pertinent to note that without this provision or without the player's false registration as a professional, that this deadline cannot be activated. Thus, the contention of the claimant in this instant case that they have waited 6 months and have not seen any reflection or change in the TMS is premature, and it is our suggestion that they should have waited for the false registration of the professional and the failure of the respondent club and the member association to update such status before they instituted this claim.